Hello, everyone. This is your host, Urvashi Chauhan. Welcome back to another episode of Courts Today by Live Law, your one step destination to all legal developments in the country. Let us start. Starting with an update from the Supreme Court in a case filed by Municipal Corporation of Greater Mumbai regarding the applicability of certain provisions of Mumbai Municipal Corporation Act to hoardings on railways lands, the Supreme Court has today directed authorities in Mumbai to ensure that no untoward incident relating to hoardings takes place in the city, considering that the monsoon season has arrived. The case here involves a group of writ petitions filed by Union of India Railways against the Municipal Corporation of Greater Mumbai and others in the Bombay High Court. The railways sought to prevent municipal authorities from applying certain provisions of the Mumbai Municipal Corporation Act to their hoardings. The railways also requested the court declare that their activities on railway properties, including commercial ones, were outside municipal jurisdiction. The High Court had ruled in favor of the railways, stating that the specific provisions under Mumbai Municipal Corporation Act do not apply to hoardings on railway property as defined in the Railways Act. However, the court had directed the railways to create a policy for regulating hoardings on their properties to ensure public safety. It had also held that railway administration is not liable to pay any tax to MCGM for advertisements on railway property unless the central government issues a notification. MCGM appealed against this decision to the Supreme Court, which issued a notice in May 2018. Today, Justice P.B. Varale referred to the collapse of a 250-ton illegal hoarding in Ghatkopar, Mumbai, on top of a petrol pump following a dust storm and heavy rains in the city last month. Senior advocate Mukul Rohtagi, appearing for MCGM, submitted that the corporation was discharging functions not only under the Mumbai Municipal Corporation Act, but also under Disaster Management Act, which has an overriding effect on other laws. When the bench specifically put to the ASG as to whether there have been no incidents on railway land, he replied that there had been none. He further alleged that by bringing in the Disaster Management Act, the corporation was trying to extend its powers. When Additional Solicitor General Vikramjit Banerjee stressed that Ghatkopar issue was not before the court, Justice Varale insisted that the High Court's observation regarding the formation of a policy by railways were of significance. The vacation bench of Justices Sanjay Kumar and P.B. Varale has listed the matter next week to enable the respondents in the matter to file a response. Stay tuned. Congress leader Rahul Gandhi today got bail in the defamation case filed by Bharatiya Janata Party against him and other leaders. The complaint is primarily against corruption rate card advertisements issued by the Karnataka Pradesh Congress Committee, which claims certain rates and commissions are charged by BJP for appointment and transfer to various positions in government departments. BJP claims it to be false and based on fanciful imagination of the accused. The party claimed that use of word trouble engine sarkar by the accused in the place of widely popular usage double engine sarkar showed an intention to malign the name and reputation of BJP and to affect its chances in the elections. Gandhi had appealed before the additional Chief Metropolitan Magistrate as directed by the court in its 1st June order. The court had earlier granted bail to Chief Minister Siddaramaiah and Deputy Chief Minister D.K. Sivakumar also in this case. A public interest litigation has been filed before the Calcutta High Court by an advocate seeking to modify the roster of Justice Amrita Sinha to prevent her from hearing cases related to police overaction or inaction. The matter was heard by a division bench of Justices Apurva Sinha Ray and Kaushik Chanda, who directed for the matter to be listed before the Chief Justice for necessary directions. The petitioner argued that Justice Sinha should be recused from police matters since her husband was under investigation by the West Bengal CID for allegedly using her position to influence an investigation. The division bench found this to be a valid question of law and referred the matter to the Chief Justice for administrative action. Madhya Pradesh High Court has permitted termination of 17-year-old rape survivor's pregnancy at 29 weeks subject to certain conditions, considering the peculiar circumstances involved. The division bench of Justice Ravi Malimath and Justice Vishal Mishra held that the pregnancy of the physically disabled survivor in this particular case can be terminated provided that it is carried out by a team of expert doctors after explaining to the minor and her family the risk factors of the procedure. After a single judge bench of the High Court agreed with the medical board's disapproval of terminating a pregnancy over 28 weeks on 6th May, the survivor's family filed a writ appeal. In the writ appeal before the division bench, a new medical report was submitted by the medical board on 8th May after conducting a court stipulated examination. The board stated that terminating the minor's pregnancy would not be permissible under the statute without express High Court permission. The court, citing various apex court judgments that talk about the right of women to safe and legal abortion, allowed the appeal, observing that permitting for carrying out pregnancy of a woman who is not in a position to manage herself will be creating great problems for her in future life. A court in Odisha's Khurda district has released Prashant Jagdev, the newly elected MLA of Bharatiya Janata Party from Khurda, on 3-day interim bail for taking part in the oath-taking ceremony of the new BJP government in the state. He was arrested for allegedly vandalizing an electronic voting machine and also manhandling polling officials during the third phase of the election in the state last month. The presiding officer of the polling booth where Jadhav is registered as a voter lodged a complaint alleging that he attempted to vandalize the EVM machine and also assaulted the polling officials as he had to stand in a queue for a long time to cast his vote. Following the complaint, an FIR was registered under various provisions of the IPC as well as Representation of People's Act, and he was arrested. Earlier, the court denied him bail. However, he again approached the court for interim bail to participate in the oath taking ceremony. The court has now released him on interim bail for 3 days, that is 9th, 10th, and 11th June, with a condition that he shall not indulge in any criminal activity during such release. The Punjab and Haryana High Court has quashed an FIR lodged against YouTuber Elvish Yadav for allegedly assaulting and threatening a social media influencer, Sagar Thakur, subject to the condition that he and his accomplices should refrain from depicting or promoting violence and substance abuse on social media. Thakur, stated to be a well known content creator, had alleged that Elvish, along with others, had beaten him brutally and threatened to kill him. Elvish Yadav and other alleged accomplices have filed a plea for quashing an FIR based on compromise with Sagar. Elvis submitted that during the pendency of the criminal proceedings, he and other accused persons in this matter have compromised. Thakur also appeared before the judicial magistrate and testified that there would be no objection if the court quashed this FIR and consequent proceedings. The court therefore quashed the FIR and highlighted that while violence portrayed in the media may seem cool or entertaining, attracting a wide audience across platforms, such content often serves to further a narrative or garner viewership and associated popularity, influencing societal perceptions detrimentally, illustrating a story and promoting hero culture. And lastly, the Bombay High Court has restrained the release of the film titled Hamare Baarah on any public platform until 14th June. A division bench of Justices N.R. Borkar and Kamal Khata was dealing with a writ petition against the Central Board of Film Certification, seeking to revoke the certification granted to the film and thereby inject it from being released. According to the petitioner, the film's trailer portrays lives of married Muslim women as having no independent rights as individuals in society. The trailer was shown to the bench, and the dialogues, which the petitioner claims are derogatory to Islamic faith and married Muslim women in India, were also pointed out. It was also submitted that despite the modifications directed to be carried out prior to the release of the film, the trailer did not mention any disclaimer or reference to the certification granted by CBFC. The counsel for CBFC said that the certification for the film was granted after following necessary procedures, and the modifications made out to the film were also pointed out. The court opined that prima facie a case was made out by the petitioner. However, it highlighted that the issue of locus of the petitioner and the need for further hearings and viewing of the film was needed. In light of this, the court restrained the makers from exhibiting or circulating the film available for viewership to the general public on any public platform till 14th June. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Livelaw. Do not forget to like, share, and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos, or consider becoming a member at just 89 rupees per month.